Because the agreement was never formed and it is null and void, no contractual obligations were imposed, including any obligations to keep information confidential. Okay, and last but not least, if you have young children or anyone who does not want to talk about Stephanie Clifford and Donald Trump, or Peggy Peterson and David Dennison, you might want them to leave the room. I'm not going into gory detail, you just might not want to have to explain it. So, just fair warning, we're going to talk about Stormy Daniels. This is a complaint for declaratory relief that has been filed by Ms. Clifford against Mr. Trump. I don't know what's in it. I believe that it seeks an invalidating or voiding or confirmation of the voiding of the non-disclosure agreement that was signed by Ms. Daniels and allegedly not signed by Mr. Trump. If you are not familiar with this story, you've been living under a rock. No, I'm not going to go any further with that. Factual background. Ms. Clifford began an intimate relationship with Mr. Trump in the summer of 2006 in Lake Tahoe and continued her relationship well into the year 2007. This relationship included, among other things, at least one meeting in a bungalow at a Beverly Hills hotel in Los Angeles County. Mr. Trump announced his candidacy for president in 2015, secured the presidency, and then on October 7th, 2016, said that he doesn't even wait when meeting a woman to start kissing her, and when you're a star, they let you do it, you can do anything. Within days after that tape, several women came forward to tell their stories about sexual encounters with Mr. Trump. Around this time, Ms. Clifford likewise sought to share details concerning her relationship. As a result of her efforts aimed at disclosing her story, Ms. Clifford's plans came to the attention of Mr. Trump and his campaign, including Mr. Michael Cohen, his attorney licensed in the state of New York. Mr. Cohen worked as the top attorney at the Trump Organization from 2007 until after the election, and presently serves as Mr. Trump's personal attorney. He is referred to as Mr. Trump's fixer. After discovering Ms. Clifford's plan, Mr. Trump, with the assistance of his attorney, Mr. Cohen, aggressively sought to silence Ms. Clifford as part of an effort to avoid her telling the truth, thus helping to ensure he won the election. Ms. Clifford and her attorney were presented with a non-disclosure agreement. At the time, Ms. Clifford was represented by counsel in California. The parties named in the hush agreement were Ms. Clifford, Mr. Trump, and Essential Consultants. As noted above, EC was formed on October 17th, just weeks before the presidential election. On information and belief, EC was created by Mr. Cohen with Mr. Trump's knowledge to hide the true source of funds to be used to pay Ms. Clifford, thus further insulating Mr. Trump from later discovery and scrutiny. By the design of Mr. Cohen, the hush agreement used aliases to refer to Ms. Clifford as Peggy Peterson and Mr. Trump as David Dennison. It imposed various conditions and obligations not only on Ms. Clifford but also Mr. Trump. The agreement also required the signature of all parties, including that of Mr. Trump. Moreover, as is customary, it is widely understood at all times that unless all the parties signed the documents together with all of its terms and conditions, then it was null and void. This is a critical assumption here. October 28th, 2 days before the election, two of the parties signed the hush agreement. Mr. Trump, however, did not sign the agreement, thus rendering it legally null and void and of no consequence. Despite the failure to sign the agreement, Mr. Cohen proceeded to cause $130,000 to be wired to the trust of Ms. Clifford's attorney. He did so even though there was no legal agreement. Mr. Trump was elected president. In January 2018, certain details of the hush agreement emerged, including, among other things, the existence of the agreement, the parties to the agreement, and the $130,000 payment. On or about February 13th, 2018, Mr. Cohen issued a public statement regarding Ms. Clifford, the existence of the hush agreement, and the details of the hush agreement. He did so without any consent by Ms. Clifford, thus evidencing Mr. Cohen's apparent position that no binding agreement was in place. Mr. Cohen stated, "In a private transaction in 2016, I used my own personal funds to facilitate a payment of $130,000 to Ms. Stephanie Clifford. Because the agreement was never formed and it is null and void, no contractual obligations were imposed, including any obligations to keep information confidential." And they go a little further. Let's see, declaratory relief, and that's it. So what they're looking for then is a judge saying, yes, this is null and void, and you can continue to act like this agreement is null and void. Well, we have something educational. I would not present this to you unless this was educational. I have something educational for you here about this case, I swear. A notice of removal was filed by the Trump administration or by the defense counsel, removing the action to federal court. This is an automatic thing. As long as they meet the requirements, they automatically go from state court to federal court. And so I thought we should go over the notice of removal, and you'll see why they did this, and you'll see what removal is. Because how often do we get to go over removal in an interesting case, really? To the clerk and the court. The federal court, please take notice that pursuant to these following laws, Defendant Essential Consultants, EC, with the consent of Donald Trump, defendants, hereby removes this civil action from the Superior Court of California for the County of Los Angeles to the U.S. District Court for the Central District of California. This court has original jurisdiction. The amount in controversy exceeds $75,000, and the parties have complete diversity, which means that they are from separate states. On March 6th, an action was commenced in Superior Court by Stormy Daniels, the action that we just read. Neither of the defendants has been served. Plaintiff asserts in the complaint one cause of action. The settlement agreement between the parties contains a broad arbitration provision which provides that any and all claims or controversies which may arise between Clifford and DD shall be resolved by binding confidential arbitration to the greatest extent permitted by law. On February 22nd, pursuant to the arbitration agreement, EC commenced an arbitration proceeding regarding the controversy at issue in this lawsuit before ADR Services, the pending arbitration proceeding. In the pending arbitration proceeding, EC seeks compensatory damages, liquidated damages, and injunctive relief of $1 million per breach. Plaintiff Clifford and her counsel were aware of the pending arbitration proceeding at the time they filed the lawsuit. They refused to comply with the arbitration agreement. Therefore, EC intends to file a petition to compel arbitration. So the major crux at the heart of the facts is that Stormy Daniels says that the agreement is null and void because Donald Trump never signed it. And even if it is somehow not null and void, it's been violated by Michael Cohen, and therefore Stormy Daniels can violate back. Sort of a eye for an eye breach of contract theory. I don't know how that actually works. The first theory of it being void is probably the stronger one. But then Trump's side is coming back and saying, no, that's a valid agreement and it contains an arbitration provision, so we have to go to arbitration. Let's get this put through arbitration. But the educational part of it is this part here, really. Grounds for removal. As set forth more fully below, this court has subject matter jurisdiction under original jurisdiction for all civil matters where the amount in controversy exceeds $75,000 and the parties are citizens of different states. This is otherwise known as diversity jurisdiction. So they talk about the amount in controversy being satisfied. The sum in the complaint is $130,000, and the damages at issue they're saying are $1 million per breach, or $20 million, which is just sort of a guesstimate of how many times she has allegedly breached. That complete diversity of citizenship exists. Basically, Stormy Daniels is a resident of the state of Texas, and Trump is a resident of, I think, New York, or at least Washington, D.C. at this time. So they are from different states. And then here's the normal prerequisites for removal. First of all, the statute provides each defendant shall have 30 days after receipt of the initial pleading to file the notice of removal. Since it's well within that, there's no problem there. It's properly removed to the Central District of California because that's where the underlying action was pending. A law requires a copy of all pleadings to be provided, which they have done. And a law requires that notice be provided to the parties and the court, which has been done. By filing this notice, EC does not waive its right to seek to compel arbitration. So they wanted to remove that to federal court, probably because they hope that they'll get maybe faster or better resolution in federal court on the arbitration issue. So we'll see. Maybe the federal court will not agree that the arbitration clause is enforceable since the agreement was never signed by a required party. Or maybe the court will find that the $130,000 was paid and kept, and that the agreement didn't need to be signed. It was effectively signed by the actions of the parties. We'll see. I really have no idea. This is another one of those contract interpretation things. I would have to research state law, which we do from time to time, and we do have a contract flow chart that helps us understand the research required to root out any ambiguity, vagueness, or misunderstanding in a contract, and it's very long. So we don't always do everything that's very long. Sometimes we skip. So thank you for joining me for that. I wanted to read what that was all about and also share what removal is about in federal court. Thank you very much to all of my supporters. My $50 plus supporters for the month of March are DJ Gilcrease, John Steele, Gavin Bernard, The Godslain, Evie Andy, Kyle Mudrock, John H. Anderson, Vera Montaigne, and Sean McNamara. When I post this VOD, I will have the $5 plus supporters scrolling on the screen. You're also on the LED panel behind me, which I update on the first of every month with all of the supporters who subscribed or supported during the previous month. And that's how Patreon charges you too. So if you start supporting in March, you'll actually be charged on April 1st, and you'll receive your recognition in April. So thank you very much. I am, of course, Leonard French, your favorite copyright attorney.